This is Barry Zalma on insurance. I'm an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant and expert witness and author and producer of these videos. Today I'd like to talk about some types of first-party property fraud. Every first-party property adjuster will face in his or her career attempts to defraud the insurer for whom the adjuster works. It is necessary that the adjuster is aware of each type of property insurance fraud he or she may encounter. Some, but surely not all, fraud types follow. The arson for profit. Arson is the intentional burning of property. It no longer is limited to specific types of property, although perhaps the most dangerous of all methods of insurance fraud. People continue to attempt insurance fraud by burning their homes, vehicles, and business structure. The FBI advises that in 2010, for example, 15,475 law enforcement agencies provided 1 to 12 months of arson data and reported 56,825 arsons. Of the participating agencies, 14,747 provided expanded offense data regarding 48,619 arsons. Arsons involving structures accounted for 45.5% of the total number of arson offenses. Mobile property was involved in 26% of arsons, and other types of property such as crops, timber, fences, etc. accounted for 28.5% of reported arsons, with an average dollar loss of $17,612. Nationwide, there were 19.6 arson offenses for every 100,000 inhabitants. Arson is not excluded in any first-party fire policy. It is, in fact, a specifically covered peril, fire. There is no arson defense available to an insurer. The defense for an arson caused by an insured to defraud an insurer is misrepresentation, concealment, or fraud of material facts. If an insured sets fire to his furniture or car to defraud the insurer, the defense available to the insurer is fraud, not arson. To defend a claim based upon fraud by arson, the insurer must prove the following. The property was insured under a contract of insurance. The contract of insurance contained a provision allowing the insurer to void insurance because of misrepresentation, concealment, false swearing, fraud, or an exclusion for intentional acts of the insured. The fire was not accidental. The fire was caused by the acts of a person or person. The fire was set by the insured or someone acting for the insured, and the fire was set for the purpose of defrauding the insurer. There is rarely direct evidence that a fire was set by the insured. Without an eyewitness or other direct evidence, the insurer can prove the insured was involved in an arson for profit circumstantially by presenting evidence of the insured's motive, opportunity, and ability to cause the fire. Motive is not required to prove arson in a criminal case, although showing a trier of fact a motive makes it easier for the trier of fact, the jury, to believe the insured caused the fire to occur to defraud the insurer. For example, Showing an insured's financial difficulties or anger at a spouse or significant other can establish motive. Also, an insured who has access to a building shortly before a fire has opportunity. If opportunity and motive combine, and all accidental causes are eliminated, fraud by arson or arson for profit can be proved. Another type of property insurance fraud that an adjuster may see is the staged theft. Stage or fake residential thefts and burglaries where the insured reports the theft of property from a residence or business when none actually occurred. For example, in U.S. versus Tam, a 2001 decision of the Third Circuit Court of Appeal, 3 defendants were convicted of conspiracy to commit mail fraud and to transport stolen cars in foreign commerce. Mail fraud and transporting stolen cars. 2 of them were also convicted of conspiracy to launder money. Following a jury trial, the appellate court concluded evidence was sufficient to support one defendant's convictions. Considering the fact that plaintiff was arrested and cited for making a false insurance claim, and that the individual he identified in a photo lineup as having stolen his car later testified to the police that he'd been approached by a woman with connections to plaintiff who paid him $200 for participating in a staged theft of plaintiff's vehicle, the denial of the claim was found to be appropriate. In New Hampshire, a defendant participated in the staged theft of his wife's jewelry at a Brockton, Massachusetts restaurant to collect $1,500 in insurance proceeds. Joseph Butler, an off-duty police officer, dining at the restaurant, observed the activities of the defendant, his wife, his daughter, and a friend surrounding the staged theft. His evidence was sufficient to allow the conviction of the New Hampshire gentleman of fraud. Then there is the staged water damage or mold claim, where an insured intentionally promotes damage by wetting down the residence or business property with a hose or disconnecting a plumbing fixture to generate water damage and encourage mold growth, is a fairly new type of property insurance fraud. It is a staged loss, regardless of the type, and as such is fraudulent. Even if no claim is filed, an insured can be accused of attempted fraud and still face criminal penalties. For example, in a New York case, a man gave his car keys to a third party who was to sell or otherwise dispose of the car. The insured was told by the third party to file a fraudulent claim against his own policy and claim that the car was stolen. After reporting the theft, the insured became frightened and did not move forward with his claim. Regardless, the insured was arrested, and the court found him guilty of insurance fraud because he took active steps to commit the fraud. The insured could not avoid criminal liability by failing to fulfill every requirement of a false claim. The most famous staged mold claims occurred in Texas in 2002. 7 conspirators were arrested by federal investigators working in conjunction with the Texas Department of Insurance. The defendants were charged with presenting insurance claims for water and mold damage to a succession of homes that they purchased, bought policies for, and then intentionally flooded the houses with water hoses or by damaging water pipes. At least one house was cooked, that is, they turned up the heat to speed up mold growth. Other members of the ring, posing as vendors and contractors, filed false claims to repair the damage and after they were repaired, they sold the homes to each other to repeat the process. 6 of the conspirators were found guilty. The remaining co-conspirator was found guilty by a federal jury for conspiracy, 4 counts of mail fraud, and 10 counts of money laundering. As the 21st century began, public hysteria about mold grew. The hysteria starting from a multi-million-dollar Texas case. The efforts of a few corrupt insureds, vendors, and public adjusters used mold to increase the value of an insurance claim by inducing a mold component that was feared by insurers until they learned about the reasons for the multi-million-dollar decision, which had nothing to do with mold, but with poor adjusting. As insureds and public adjusters became mold savvy, the temptation to create a covered loss scenario where none would otherwise exist became almost irresistible. On occasion, adjusters are faced with an insured who has post-dated a loss. This fraud technique involves a loss at a time when an individual has no insurance or inadequate insurance. Following the loss, the individual applies for insurance or increases the limits of an existing policy so she or he have sufficient insurance to cover the loss. After a period of time, usually several weeks, a fraudulent claim is submitted for a loss reported to have happened after the new policy came into effect. Failure of the insurer or its agent to see the property or obtain a current appraisal by a professional valuer of the type of property the risk of loss of which was to be insured, especially if the insurer has included the items on its schedules before issuance of a policy, is an invitation to this type of fraud. This type of fraudulent claim occurs because insurers are obligated to treat each other and every applicant and insured with utmost good faith. As a result, insurance is issued based upon unverified representations by an insured. If the insured misrepresents the description, age, or value of the property, the insurer may either rescind the policy or deny any claim based on the misrepresentation, concealment, or fraud condition of the policy if it can find evidence to prove that the condition was available and required voidance of the coverage. And finally, there is paper property. This sort of fraud involves property that never existed or was never owned by the insured. Paper property can appear in a staged loss or in an inflated claim. In the presentation of the claim, the insured produces a receipt, an original or a duplicate, or an appraisal. The document is either fraudulent, examples include the use of computers or even whiteout paint and a photocopier to change the name of the owner, or represents the value of an item owned by another individual. For example, an insured purchased jewelry at a department store on a credit card, took the jewelry to an appraiser, obtained a valid appraisal of the value of the item, and then returned the jewelry for full credit to the department store. The jewelry, no longer in the insured's possession, was insured under a personal articles floater. The insured waited 3 weeks after the issuance of the policy and reported she had lost the item of jewelry. Her claim failed only because the adjuster went to the vendor to verify the sales receipt, only to find that the vendor showed him the item in his display case because he had it not sold it again after she returned it. In December 2012, Barry William Kallenberg, a rabbi, was arrested on dozens of charges in South Florida after authorities said he bilked companies out of tens of thousands of dollars in false insurance claims. Kallenberg was arrested at Miami International Airport on one count of organized scheme to defraud and 73 counts each of grand theft, false insurance claims, and false supporting insurance documents. In addition to his arrest in South Florida, he pled guilty before Bergen County Superior Court Judge William Meehan to a criminal accusation which charged theft by deception, a third-degree crime that carried a maximum sentence of up to 5 years in state prison and a fine of $15,000. In December of 2012, a guilty plea hearing before Judge Meehan, Kallenberg reportedly admitted that he created a fictitious real estate management business group in order to purchase group health insurance for 5 individuals not entitled to group coverage because they were not bona fide employees of a bona fide business. Similarly, in Safeco v. Rostrum, the insured created false documents to show she had replaced property lost in an earthquake to defraud Safeco. The court concluded that the insurance policy was void as to Carla Rostrum, and the court awarded Safeco $367,143 in benefits, plus post-judgment interest at the legal rate. Safeco was also entitled to investigative expenses in the amount of $3,196 and investigative costs of $3,820. Her husband, however, filed a suit claiming he was an innocent spouse and recovered the full amount of his claim. So justice was done, and then again maybe not. This video was adapted from my book, The Compact Book of Adjusting Property Claims, 3rd edition, which is available as both a Kindle book and a paperback from Amazon.com. If you found this video to be useful or interesting to you or your colleagues, please pass it on. It's free. And please subscribe to my Rumble channel, my YouTube channel, and my blog so that you can learn of future videos and future blog postings. Thank you for your attention.